What led a U.S. court to halt Trump administration's immigration crackdown in California? A federal judge in the United States has issued a major blow to the Trump administration's immigration crackdown by halting what the court described as indiscriminate stops and arrests across 7 California counties, including Los Angeles. The temporary restraining orders were passed by U.S. District Judge Mamiyo Asimensa Frimpong in response to a lawsuit accusing immigration agents of unlawfully targeting Latino communities. According to filings, U.S. immigration authorities detained people based solely on their appearance, language, or where they worked, without warrants, probable cause, or due legal process. The judge said there was a mountain of evidence that such unconstitutional practices were taking place. The case was filed last week by immigrant advocacy groups and 5 individuals, 3 undocumented workers and 2 U.S. citizens. Among the citizens, 1 was reportedly detained despite presenting valid identification. The American Civil Liberties Union ACLU of Southern California, which led the legal action, said the Trump administration's tactics violated the 4th and 5th Amendments of the U.S. Constitution, which protect against unlawful searches and guarantee access to due process. The judge found that immigration agents from the Department of Homeland Security (DHS) were conducting roving patrols and arrests without reasonable suspicion. These actions were not based on credible intelligence or surveillance but on superficial factors such as race, clothing, or worksite location. In one case cited in the lawsuit, everyone at a car wash was detained except for 2 white workers. Another plaintiff, Brian Gavidia, a U.S. citizen, was reportedly assaulted and detained while working at a tow yard in a Latino neighborhood. The court said these patterns pointed to racial profiling. Judge Frimpong noted during the hearing that DHS had failed to provide even a single report justifying why someone was targeted. "It's hard for the court to believe you couldn't find one case with a report of why someone was targeted," she said, calling out the absence of documentation. The ruling includes 2 temporary restraining orders. The orders apply to the U.S. Central District of California, covering Los Angeles and 6 other counties in Southern California. B18 is a temporary holding facility in downtown Los Angeles operated by Immigration and Customs Enforcement (ICE). Advocacy groups alleged that detainees at the facility were not informed of their right to legal representation and that lawyers were often denied entry. Mark Rosenbaum, a lawyer for the plaintiffs, testified that in one incident on June 7, attorneys tried to read detainees their rights through the windows of a bus, but government drivers honked horns to drown them out. Chemical agents akin to tear gas were reportedly used during that confrontation. He added that the facility lacked beds, adequate food, and medical facilities, conditions he described as coercive, pushing detainees to sign deportation papers without speaking to a lawyer. Although government attorneys claimed that access was only restricted during violent protests, Rosenbaum said lawyers were denied entry even on quiet days. The White House strongly objected to the ruling. Spokesperson Abigail Jackson said, "No federal judge has the authority to dictate immigration policy. That authority rests with Congress and the President. Enforcement operations require careful planning and execution skills far beyond the purview or jurisdiction of any judge. We expect this gross overstep of judicial authority to be corrected on appeal." The Department of Homeland Security also rejected the claims. Tricia McLaughlin, a DHS spokesperson, said the allegations of racial profiling were disgusting and categorically false, and added that a district judge is undermining the will of the American people. In court, government attorney Sean Skedzielewski argued that immigration officers relied on prior surveillance and intelligence, not race, and acted based on targeted, individualized packages. He maintained that agents undergo training to comply with constitutional rights, including the 4th Amendment protections against unlawful search and seizure. California's political leadership, including several Democratic officials, welcomed the court's decision. Governor Gavin Newsom wrote on X, formerly Twitter, "California stands with the law and the Constitution, and I call on the Trump administration to do the same." Justice prevailed today. The court's decision puts a temporary stop to federal immigration officials violating people's rights and racial profiling. California stands with the law and the Constitution, and I call on the Trump administration to do the same. https://t.cuz63bow1kq Governor Gavin Newsom K. Governor July 12. 2025 Los Angeles Mayor Karen Bass called the judge's decision an important step toward restoring safety, security, and defending the rights of all Angelenos. L.A. has been under assault as masked men snatch people off the street and chase people through parking lots and summer camps. But today, the court ruled in favor of the United States Constitution. This is a win for Los Angeles, and it is a win for cities all across the nation. Pic.twitter.com Cook 13 Mayor Karen Bass Mayor of July 12, 2025 Nanan Swipe left for next video. The orders issued are temporary and will remain in effect as the case continues. The court has instructed the federal agencies involved, including DHS, the FBI, and the Department of Justice, to maintain detailed records of all arrests and share them with the plaintiffs' legal teams. This will help determine whether patterns of unlawful enforcement continue. A separate ruling from April had already barred U.S. Customs and Border Protection from making warrantless arrests in Eastern California. Together, these orders point to growing judicial resistance to broad-brush immigration enforcement measures. Latest blogs.